for adjournment today, but I have some urgency. So may I pray that it may be taken up after 2 weeks, fixing a date, my lord. You are sued for a specific performance of contract.
You are for the appellant side.
Yes.
As agreed by both the sides, list the matter on date of details of 2 weeks. 22nd date.
Much of, deeply objection.
May it please,
Yes.
I am for the respondent, but item number 20. So today I want to take the adjournment.
I'm for the appeal, my lord, by making early hearing application, my lord. I fix this today. So my only submission, my lord, that may be fixed, my lord. On that is, can it be on, my lord, on
13.
Uh,
13.
15 or
Learned Counsel Miss
S. Chakraborty.
S. Chakraborty for respondent number
Respondent
one.
number.
Private respondent or government?
respondent?
Respondent, all respondents.
For all the respondents?
Yes.
For the respondents has prayed for adjournment. Learned Counsel Mr. P.K. Deka has raised objection
Yes, my lord.
due to the adjournments taken by the respondents. List the matter on
15, my lord. 15.
15.
Deeply obliged.
Much of.
Thank you, Your Lordship. Lordship, I beg to mention item number 21, Your Lordship. With the consent of the other side, Your Lordship. I'm for the respondent, Your Lordship. Madam, maybe it
Learned Counsel Mr.
teach it.
T. Chetri with the consent of the other side
Yes, Your
has prayed for adjournment. List the matter on
15th, Your Lordship.
You want a date?
Yes, Your Lordship.
There'll be too many matters on 15.
Then any other date?
20 May.
20. Much obliged.
May I pray, your lordship? Lordship, with the consent of the other side, I beg to mention item number 5 of today's list. I am for the petitioner, lordship. Can it be taken up after 2 weeks?
Learned Counsel
M.
Mr.
Das. M. Das.
M. Das with the consent of the other side has prayed for adjournment. List the matter after 2 weeks.
First, the interim order to continue.
Interim order shall remain in force till then,
Obliged.
till the next date of listing.
Obliged.
Till the next date of listing.
My pleasure. My lord, with the consent of the appellant side, I beg to mention item number 16, my lord. Kindly pass over for the day, my lord.
Well, I am for the appellant, my lord. Let it be after 4 weeks, my lord. Some
With the
talks of
consent of the
compromise
other
are also
side,
going.
The Learned Counsel Mr.
M. Hussain, my lord.
M. Hussain has prayed for adjournment. List the matter after 4 weeks. Any interim order?
Interim order is there.
Interim order shall continue till the next date of listing.
Most
May I please, your lordship? I beg to item 13, my lord. Hearing, my lord. With the consent of the other side, my lord. Let it come after 2 weeks, my lord.
Learned Counsel Mr.
A.K. Talukdar.
I am for the appellant, my lord. The date may be fixed.
Learned Counsel for the appearance, Mr. A.K. Talukdar, with the consent of the other side, has prayed for adjournment. List the matter on 22nd May.
May it please your lordship. Your lordship, with due consent from other side, I beg to mention item number 12 of today's list, your lordship. We are for the respondent, your lordship, respondent number 3. Any date, your lordship, after 3 weeks.
You for the insurer, no?
Yes, your lordship.
Learned Counsel Miss
Or your
P.
lordship, any
Bhattakar?
date next week.
Next, lordship.
P.
Next week.
Bhattakar?
Yes, your lordship.
Learned Counsel Miss P. Bhattakar, for the respondent number 3 with the consent of the other side, has prayed for adjournment. List the matter. You want a date
Lordship.
or 3 weeks?
15 May. 15 May, your lordship.
Not on 15 May. Some other date?
Any date, your lordship.
29.
Oblige, your lordship.
May I please, your lordship?
Hmm.
Item number 10. In this case, in this matter, I have recently engaged as the retainer of the CBI. So matter is fixed for hearing. So I am requesting for 2 weeks or 3 weeks time.
Learned Standing Counsel for the
Yeah,
CBI.
recently.
Miss-
We are item number 10.
Yes, item number
Yes,
10.
lordship, we are for the petitioner on
Okay,
behalf of
Miss-
PM Sodri.
Miss
M. Kumari, Manorama Kumari.
M. Kumari, with the consent of the other side, has prayed for adjournment. List the matter on
At what time it is?
Any date after 3.
Any date after 3 weeks.
Okay, we'll give a date, huh? This is an old matter.
Okay, fine. 29th of May. Much obliged.
Must oblige.
May I please, your lordship? Lordship, I beg to mention a item for listing, RFA, it's a 2019
We'll
matter,
have to mention before justice. You know. Here it is.
which is for hearing, my lord. So can it be on 13th of this month?
Are you? Yes.
Obligement.
May it please your lordship, I beg to mention item number 22. Matter may be adjourned for the day, lordship.
Learned Counsel, Mr.
M. Ahmed.
M. Ahmed,
Yes.
for, you are for appellant.
Yes, lordship.
On behalf of Learned Counsel, Mr.
M. S. R. Chaudhary.
Oh, our learned counsel, Ms. R. Chaudhary, has prayed for adjournment. This is, other side is not reflected.
Lordship,
You have
other
not
side,
issued
other side,
notice till now?
no, they have not made any appearance.
They have not appeared. List the matter after?
Any date after 3 weeks.
List the matter, any date? You want a date? 3 weeks, list the matter after 3 weeks.
May I please, your lordship, with the consent of the respondent, I beg to mention item number 9, lordship.
May I please your check? I'm for the respondent.
Lordship, this matter may be adjourned for today, lordship.
My lordship, it is listed for orders, or service is complete in this matter.
So
They
then
come up
we
for
will
admission.
Come for admission, lordship, after
Yes,
3
please
weeks.
come up for admission, doesn't the order matter to sign up? Just a moment, huh? We'll pass the order, as it is fixed order, service is complete,
Yes, lord.
then we'll release the matter for admission, or it has been admitted already.
No,
It
is
has
not
been admitted. There is an interim also, lordship.
CRP,
No.
CRP,
Yes.
do we have the LCR?
No.
No, then we'll call for the LCR.
On last.
Do we need the LCR in this case?
Yes, my lord, it may be called.
Because I have no idea about the case. We'll
So
call
this
for
is
the
complete
LCR.
on last date also, last date order text, this is complete.
Yes. Whatever LCR, has it been called earlier?
No, no, my lord, it has not been.
We need the LCR. This is relating to what? No idea at all.
It's relating to an implement application, which was allowed.
So we don't need an LCR.
My lord, we will file our counter based on record all the documents which is required.
Or then we'll fix it for orders only.
My lord.
Yeah, you'll file counter affidavit.
Right.
Learned counsel, what is your name?
S. Paul, on behalf
Paul.
of A. Bhattacharya.
On behalf of
A.
K.
Bhattacharya, A.
On behalf of learned counsel, Mr. K. Bhattacharya, representing the petitioner,
Petitioner, lord.
AK Rai on
is
behalf of
present. Full stop. Learned counsel,
AK
Mr.
Rai on behalf of respondent number 1.
AK.
Right.
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 AK Rai is present on behalf of respondent number 1. Anybody else? Behalf of respondent number 1, and has submitted that he will, and that the respondent will file counter affidavit. List the matter when you want?
Lordship, there is an interim, it may be continued.
Yes.
After 3 weeks.
List the matter after 3 weeks. Interim order shall remain in force till the next date of listing.
Much obliged.
Wait, please, your lordship. Lordship, item number 8, that may be fixed at 2, lordship.
Okay, at 2, yes.
Eight. At 2, lordship.
Yes.
Please, your lordship. Lordship, I beg to mention item number 17, lordship. With the consent of the other side, I pray for adjournment for today, lordship. I am for respondent number 2 to 4.
Learned counsel, Mr.
S.A. Bakhtiar. For an alarm, respondent number 2 to 4.
Your name is not reflected in the.
Yes,
call.
lordship, my senior's name is there, N.
S.A.
Alam.
Bakhtiar on behalf of learned counsel, Mr.
N. Alam.
N. Alam, representing the
Respondent 2 to 4.
respondents 2 to 4 has, with the consent of the other side, has prayed for adjournment.
Lordship,
Other side
second,
is present.
a date may be fixed of second week of June, lordship, next month.
Other side is present.
Other side, no.
Not
We have
present, but
informed
you have taken the consent.
We have informed and we have
This is
taken
the
the
matter,
consent.
second week of June, not taken. 8.
Lordship, can it be after 10th, lordship? It will be difficult because Eid, the occasion of Eid is there, lordship.
Okay, 10 to June, we should be.
After-
17.
Lordship, much obliged.
Lordship, item number 18, Lordship. Actually, not convenient, that is why today kindly.
You are asking adjournment?
Yeah.
Learned counsel, Mr. D. Kame.
No, R.A. Rongmei.
R.A.
Rongmei.
Rongmai on behalf of learned counsel, Mr. D. Kame.
Yeah, actually, he's my junior. D. Kame is my
Okay,
junior.
okay.
Actually,
Oh, okay. Are you a senior advocate?
Yeah.
Learned senior advocate. Mr.
no,
D.
no, no. Actually,
Learned counsel, Mr. D. R.A.
R.A. Rongmei.
Rongmai.
Rongmei.
Rongmai. Comma, with the consent of the other side. The other side.
Lordship, matter may be fixed.
Has prayed for adjournment, list the matter on date. 27th of May,
Lordship, 3rd July, June,
3rd June,
3rd June,
3rd June.
No.
Huh?
Pardon.
3rd June, yeah. Tuesday. Highly obliged.
May it please your lordship, I beg to mention hearing item 11, my lord. May come up after 2 weeks.
Have you taken consent from the other side?
Yes, my lord, we have informed.
Learned counsel, Miss
As Musahari.
S. Musahari on behalf of learned counsel, Mr. G. N. Saiwala.
No, my lord, as the senior counsel. We are further responding to
Okay,
every
learned counsel, Mr. S. Learned senior advocate,
senior.
Mr. S. Doctor, with the consent of the other side. You have taken consent,
Yes, my lord, we have taken.
has prayed for adjournment, list the matter on when do you want?
After 2 weeks, my lord,
After 2 weeks.
obliged.
Item number 1.
This is a regular bail application, Your Lordship. The petitioner is behind the bar for last more than 196 days, Your Lordship. 196 days, Your Lordship. Earlier, this honorable court has
Charge has been submitted.
already trial has been proceeded, Your Lordship. Now, I have
Let the scan copy be called and notice my POXO. Notice POXO.
it's a
Murder case.
no, it's a first of all, under 87 there is a case has been registered against the accused persons. Lately, Your Lordships, on the basis of an prayed before by the IO, section 6 of the POSCO has been added. Already trial has been proceeded. Now I have also annexed the victim statement and the informant statement. Both the persons has been prayed before the learned court below to exonerate the petitioner from the charges of the POSCO because there is a love in relationship. Moreover, this honorable court on earlier occasion granted bail of the petitioner. But when we submitted the bail bond, we have come across that section 6 has been added. But the learned court has been tried the offences under section 6 of the POSCO Act, and the trial has been committed is in comments. And during the trial, Your Lordships, the victim girl and the informant has categorically stated that there is a living in relationship. There is no any sexual.
You have annexed the evidence.
Lordships, I have annexed L. It's a clear picture of has been
Page number.
page number 42. It's a victim statement, Your Lordships.
Please read.
First lordship, the grounds of arrest were not furnished to me, and second lordship, prolonged incarceration.
Let the scan copy be called for.
Call for the
And
scan
request
copies,
commercial.
please airport record along with the scan copies of the CD list the matter.
And it will lordship on 16th. 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 Highly.
Second bail application, my lord. Earlier was rejected by your lordship. I have annexed the order. I was granted the interim bail. After getting interim, my lord, my statement has been recorded, my lord. And I have several occasions I appeared before the my lord IO. Your lordship, kindly see the last my lord order passed by your lordship. This page 23, my lord. Page 23.
Yes.
Heard Mr. R. Dhawal and counsel for the petitioner, so Brahmo so is who is the first was filed this application under 482 for the prayer for PRS bail of his apprehending arrest in connection with the so under section to heard Mr. KK Poraswal additional public prosecutor for the FIR.
I have rejected it, no?
My lord.
I have rejected it.
Yes, I have your lordship. Your
Call for the CD.
Oh, my lord, I just 3 count I'm placing because your lordship that actually this FIR was lodged by a third party, not by the victim family, my lord. That lady was in my house, my lord. I'm a school teacher in my house.
Story.
For 3 months only. Now, my lord, no, my lord, another
I have
progress.
read the CD.
No, now another progress is there, my lord. Now, my lord, police has my lord needed requisition to police has given a requisition to examine the dead body. And they buried it, your lordship kindly see, I have annexed that, my lord. Page 20, my lord. Page 20. So that latest report, my lord, that has to be furnished to be for this one, at least. Because now, my lord, probably police on the payout of they made a payout before the CJM that I mean that they may be allowed to dig out the dead body and make the examination of the dead body, my lord.
Maybe for DNA test and all these, my lord.
Yes, I am ready for DNA test also.
We'll call for the CD.
My lord. But I am a
Call
school
for the
teacher, my lord.
After
If
the
possible, I may be protected, my lord. I am already, my statement has been recorded. No, my statement has been
After
recorded.
allegation of rape.
No, your lordship can, allegation
the
of
CD.
rape is not there. In fact, my lord, although there is there, my lord, section is there. My lord, your lordship can,
We'll need the CD.
my lord.
Call for the CD along with the state, call for the CD along with the PM report,
My lord,
along with the PM
latest,
report.
latest, my lord, inquiry report, my lord.
Call
Because
for the
your lord,
updated CD along with the PM report, list the matter on.
21st.
my lord. Deeply.
Item number 4 for admission.
May I please your lordship? Lordship, the matter may be kindly pass over for the day as my senior is having some personal inconvenience.
Learned Counsel Miss
Jay Sharma on behalf of A. Iqbal.
has, with the consent of the other side, has paid for adjournment, list the matter on 2 weeks.
Obliged.
Item number 6, bail hearing.
May I please your lordship? The status report was called for lordship and lordship, I am on a long incarnation. And my instruction goes lordship, not a single witness has been till date examined lordship.
What do you have?
Yes, my lord, status report has come, my lord, I have checked. As part of that report, my lord, last date was of 24th of April for evidence only, my lord. Few days, my lord, earlier, my lord, no witness examined. I will face my trial, lordship. I may be allowed to go on bail. I can prepare my defensive inside, lordship. How can I prepare my defense, lordship?
What is the case?
No,
Under which sections?
It is commercial quantity 25.23 to 3
On
kg
what
of
grounds
ganja.
are present today?
Ganja, lordship.
Commercial quantity, how many kilos?
My lord, I am praying
How
for
many
bail.
kilos?
25 point. Just a moment, lordship. 25.23 kg to 20 kg is the
What are
commercial.
the grounds? No
Lordship,
grounds of
my
arrest.
ground is long incarnation, lordship.
Long incarceration.
Long incarceration, my lord. Long incarceration, lordship, will kindly see there are many several
This is
judgments
hearing,
of
no bail hearing. We have the
bail hearing.
LCR.
Bail hearing. There are several judgments of the Honorable Supreme Court, lordship. My lord, since
24, how many kilos of ganja?
25.23 kg.
25.
Lordship is well aware of the judgment of Ravi Prakash versus State of Odisha.
You are behind bars for how many years?
Not even completed 1 year. Let me submit. It is my case. Why you are
How many days?
to 366 days, 401 days in custody, lordship.
How many days?
401 days in custody. My brother is saying not even 1 year. I am 401 days in
How many
custody.
witnesses have been examined?
Not a single witness. Lordship. Charge has been already framed, lordship. I will be allowed to go on bail. I will face my trial, lordship. And they are the local guys, lordship. It is not that they are from outside, lordship. They are local
Where
guys.
is the FIR? Let me see. Let me check.
Yes,
the
yes,
FIR.
yes, lordship, yes. Lordship will find the FIR in page number 13, lordship. Person Motiur Rahman.
Kharka Bahadur, Hare Krishna, and Dipankar.
Lordship.
I forgot the names of the who are they? Kharka Bahadur and
Dipankar. These are the
these two
Kharka
are
Bahadur and Dipankar are the petitioner, lordship. And from my instruction goes that from Kharka Bahadur and Dipankar nothing has been recovered, lordship. Face the trial, lordship. They're local guys. No place to fled away. Kharka Bahadur, lordship, he is from village Namati, Majbhat, Udalguri. Dipankar is also from Nanati, Kaha, Majbhat, Udalguri. Both are the local guys, lordship. On the last occasion, lordship said that lordship will consider today because of the long incarnation, lordship. Incarceration. New लगाना होगा.
No.
Lordship, there is one judgment. Then let it be kept pending, lordship. Till sometime.
Learned Counsel.
Till sometime, let it be
Mr.
kept pending. I don't know when the Caesar witness will be examined, whether examined or not, I don't know.
Has prayed for adjournment. call for the up-to-date status report relating to the pendency of the case of
Let some time go, Lordship.
special, okay.
Let's
Wait for adjournment, list the matter on 23rd of June.
23rd of June. Status report may kindly be called for, Lordship. Otherwise, you will not know.
Meanwhile, call for the status report of the pendency of the special case number,
Lordship, the special case number is
special N
uh,
19 of 2024 pending in the.
yes. Special N 14 of 2024, Lordship. Pending in the court of Lanet Special Judge Darang Mangal.
Here it's written as 19. 19. Not you. Our court.
Then it will be 19.
Huh?
19.
19. Okay, pending in the court of the special judge Mangal.
Mangal.
Number 7.
Yes.
May it please your lordship. Here in this case, earlier, your lordship remembered that I could not produce that Probir Purkasta judgment, so your lordship rejected my application, lordship.
This also?
This case, lordship. This is the second prayer. Poor person, he could not go higher court, so he renewing prayer.
But this the case is being subjudice in the Supreme Court. Shall we go
No,
ahead with the grounds of arrest now?
No, in that
It's
case,
subjudice in the Supreme Court, no?
that matter is already, that issue is heard by court number 19, lordship, that whether we can proceed or not. And considering all aspect, lordship, now that court are also granting bail. Yesterday also granted bail, lordship.
Court number 19.
Court number 19. This
Yes.
issue was raised, yes, similar issue was raised. That order is not uploaded yet. I can give the case number, lordship.
Then
That-
you get the uploaded order, then place it. We'll fix a date.
At two, lordship.
You get it
Yes,
at 2. If
yesterday.
it's not uploaded at 2, then
Yesterday, lordship, other coordinate banks also granted bail. So therefore, I will place that at two, lordship. Can it be at 1 PM, lordship? Can be 1 PM? At
1
two,
PM?
yes, at two, lordship. At
1 PM, I can hear you, but they also need a break. Staff and.
before
yes,
one,
they need a break.
before one, lordship. Because at
One
two.
can be before one.
Obliged.
Appellant is not there, Lordship.
Appellant.
I'm responding. I
It's
think
for hearing.
hearing, Lordship. Because too many cases are mentioned, so that it has.
Item number 14. नहीं?
Can fix it next
Appellant
week.
has taken date, I think.
Date.
हाँ. 14 लिखी से, more लिखी से. Tick mark भी दे सकते.
In the
क्या ना
list, it is not mentioned.
More 14 और tick mark भी दे सकते. भूल कर देंगे.
They have taken time.
Confirm question विचार करो. Just a moment, just a moment.
Otherwise also, since they are not there, Lordship, then you can fix it next.
No, but I think I have passed an order, that is why.
Oh, in the list, it's not mentioned.
Wait.
In the list, they have pasted. I have another matter, part third, in another court.
Nahwani, Learned Counsel Ms. R.D. Mozumdar is present on behalf of respondent number 1, whereas the appellant is not represented. List the matter. When do you want?
Next week, Lordship. Or as convenient.
List the matter after 1 week. Yes, list the matter after 1.
I'll apply, sir.
Item 15 on hearing.
16 to list the 16 to write need 14 to write. 16 to write to do, no?
I am for the respondent also. On last occasion, the stay order has been vacated on the list of application with the money decree, and no deposit has been made by the applicant. And lots of cases like this, plaintiff has a plot of land of rupees 1 bigha, and in lieu of construction of building, interest has been given for it to construct a multi-story building in the plot of land.
I cannot hear you properly. You'll have to lift up the
Yes.
speaker, yes.
Multi-story building is directed to be constructed to the builder. Builder has constructed the building, and in lieu of construction of the building, you are supposed to pay rupees 72 lakhs without any flat.
This is hearing.
First appeal hearing.
What about that?
Let's see, on last occasion, the order has been vacated. Because we have filed an application that stay order has been obtained ex parte without depositing anything. It's a money decree. Lordship is aware that in case of money decree, they have to deposit 50, at least 50%.
Yes, they have to
So
deposit.
without deposit, they have obtained a stay order.
Money decree relating to what, bank loan or?
No. This is an amount to be paid
Uh,
by the builder
uh,
to the owner of the plot of
Builder
land.
to the owner, because I couldn't hear you, that is why I'm asking
Yes.
again.
I have a plot of land measuring 1 biga. I have allowed the respondent appellant herein to construct multi-story building in the plot of land. Lordship will kindly surprise. In this particular case, 1 biga of land, only 72 lakhs has been agreed to be paid. These are two ladies, and they have given only 72 lakhs they agreed to be paid. Out of that, he has not paid the total amount, and advance check has been given that it will be honored by the banker. Check has been dishonored. He constructed the building and sold out the flat, but money has not been paid. And thereafter, under the NIX suit has been filed, a case has been filed in complaint case. Hereafter, he paid rupees 5 lakhs and case has been withdrawn that he will pay the amount. After that, he did not pay the amount. And ultimately, plaintiff has to file a suit for realization of the amount. And ultimately, suit has been decreed. Now, Lordship, the appeal.
And now, after vacation, they are not there. So good case to be dismissed.
Dismissed for default, Lordship.
Yes, of course, dismissal default, but let us give them one opportunity. Last date. If they do not appear, then we'll dismiss it for default.
Next week, Lordship.
Yes.
Lordship may record that appellant has not appeared.
I have dismissed cases for default, but I always
But dismiss for default is not, Lordship, we are not getting any relief because they will file an application for readmission of the appeal.
I know. No point actually. Usually I give one last opportunity and then I dismiss it for default.
Lordship.
There's no point in dismissing it again, restoring it again, no point. Learned Counsel, Mr.
S.K. Goswami.
S.K. Goswami is present for the respondent number 1 and 2. The appellant is not represented today. List the matter for hearing positively on the next date fixed on failure of appearance of the appellant. Necessary orders may be passed.
May I submit one thing, Lordship? Lordship may record earlier occasion the stay order has been vacated.
It is also submitted by the learned counsel for the respondent that as the how much percent as the money deposit, as the appellant has not deposited the advance, no?
Deposited the 50% of the awarded
Or
amount.
deposited 50% of the awarded amount. The earlier stay order has already been vacated. List this matter for after 1 week positively for hearing.
Dear Peter. 13 May. 13 May.
All right.
Oblige.
नाही. ठेवली नाही की कमान घाट आहे बघा ना. দুটাৰ মানে হেৰি এখেত আৰু এওঁ কি হ'ব দুটাৰে আকৌ ক'ৰবাত কিবা কাম আছে নেকি ঠিক আছে হ'ব দে দুটাতে বহি দিম আৰু এইটো থৈ দিবা 11টাই বজা নাই কালি ইমান বুক কেছ দিলা Yesterday I couldn't complete and today no case. Okay.
So all those issues were discussed in this case.
Ah.
And judgments of Honorable Apex Court also. And the fact that there are Supreme Court judgments which says that awaiting that if any judgment is reserved or referred to larger events, that High Court should not wait for their outcome.
That may be mentioned, my lord, in the order.
Yes.
Yeah, in paragraph 14, Lordship may kindly see.
Paragraph 14, no?
Yes.
Okay. You have you have relied on this
Yes.
judgment?
Yes, and thereafter that judgment is quoted, that language, Lordship, that paragraph 35, paragraph 14, that Supreme Court judgment is quoted last line. we are seeing before us judgments and orders by high courts not deciding cases on the ground that leading judgment of this court is on this subject is either referred to a larger bench or a review petition relating thereto is pending. We have also come across examples of high court refusing deference to judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law. We make it absolutely clear that the High Courts will proceed to decide matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not.
With that direction.
Lordship. Considering the.
Otherwise, I have decided your case when the judgment was fixed for
Lordship.
order. I have decided
Lordship.
2 cases.
Lordship.
One case.
Two cases.
Two cases I have decided. So, okay,
But
then-
only in this technical ground, my lord. Only in the ground of
Without a-
technical. Otherwise, material said here.
material, but
Only-
council
only-
list, according to you, has not been have not been communicated grounds of arrest.
Not
Have you
communicated.
given
That not communicated. but-
certificate copy of the
Yes,
grounds
yes.
of arrest?
Those I have annexed, Lordship will find
Page 21.
page 21 and 22.
Information is there, but the grounds is not properly given. It's not like that it was not informed, but
But as.
not informed.
As per Probir Purgaster judgment, that particulars and why the arrest was necessary, those things has to be there.
Yes, it has to be made.
That one judgment passed by your lordship, in similar thing, that also I have given to your lordship.
So he's behind bars for how many days?
For 2 years, 6 months, more than 2 years, 6 months, lordship. Since 6/10/22.
Third learned counsel, Mr. A. Ahmed for the petitioner. You give me the dates, huh? Petitioner, Imamuddin, who has filed this application under section 483 of the BNWS 2023 with prayer for bail, as he is behind bars since 6/10/2022. Okay,
Lordship.
in connection with special NDPS case number 146 of 2022 arising out of Rathore case number 290 of 2022 under section 21 within bracket B within bracket Roman 2 within bracket C stroke 22 within bracket small b within bracket all small b, Roman 2 within bracket small c of the NDPS Act read with section 25 within bracket 1 within bracket small a of the Arms Act. It is submitted on behalf of the petitioner that the grounds of arrest has not been communicated to the petitioner and he was not at all aware of the grounds of arrest. The petitioner has relied on the decision of the Honorable Supreme Court in Bobby Purgaster versus page number
That
21, no?
Probir Purgaster judgment, that compilation I am handing over to your lordship.
Okay, I got it. Probably Purgaster versus State of NCT Delhi, wherein it has been, which paragraph?
Paragraph lordship, Probir Purgaster's paragraph 30, 37, 45 and 48.
Give me one relevant paragraph.
That 48 will do, lordship. 45 and 48.
47,
45 and 48.
45 and 48. ইয়াতে compilation দিয়া আছে page number হ'ব compilation or page number হ'ব Bobby Purgaster versus
State NCT of
State of
Delhi.
NCT of Delhi reported in 2024 within bracket 2024 within bracket 8 SCC 254 wherein it has been observed that page number 49 of the compilation তাতে আছে paragraph 45 or 48. The learned additional PP next paragraph. The learned additional PP Mr. MP KK Parashar has raised serious objections stating that there are incriminating materials in the case diary against the petitioner, full stop. Although the grounds of arrest were not detailed to the petitioner, yet the grounds of arrest have been communicated to the petitioner, full stop. I have also scrutinized the notice of information under section 450 CRPC, as well as the arrest memo marked as annexure 2 and annexure 3 of the petition. It is true that the grounds of arrest were mentioned in a cryptic manner. The grounds of arrest were not properly communicated to the petitioner. I have also relied on the decision of the Honorable Supreme Court in Bobby Pucasto versus in Bobby Pucasto's case, Supra. It is also true that the petitioner was apprehended in connection with transportation of what is the material?
Heroin, Lordship, 237 gram and methamphetamine, 800 grams.
237 grams of
Heroin,
and 843
grams of methamphetamine.
and 843 grams of methamphetamine, no?
Lordship.
METAPH, what is the spelling?
Spelling, Lordship. It is in Lordship's order that page.
Yaba tablets, short form. It is famously known as Yaba tablets.
Containing methamphetamine.
However, as the grounds of arrest have not been properly communicated to the petitioner,
What tablets?
I deem it proper to enlarge the petitioner of bail, enlarge the petitioner on bail. In view of my foregoing discussions, the petitioner so and so is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from number 1, shall refrain from such activities with which he is alleged, comma, next line, number 2, the petitioner shall not jump the bail. So he is not local to that
He
place.
is
no?
local person, Lordship, of that.
The
we don't-
petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. On breach of any of the bail conditions, the learned trial court is at liberty to immediately cancel the bail granted to the petitioner. All right.
Obliged.
So this is the A2 compilation today. Page number 49. Huh? This is not required. This is not required. Actually, I also believe in this when there is no specific circulation. I have already, but sometimes because
Lordship.
there may be jeopardy.
Lordship.
Once the judgment is delivered, and
And
then
in fact,
come and find something
yes,
else.
and in fact, that judgment is regarding whether that arrest memo is to be given prior to arrest or after arrest. That also will probably not affect in those judgments.
Yes.
Because it is admittedly because when a person is caught red-handed, the police cannot serve him copy. That has to be
Immediately.
subsequently. Obliged.
Please, your lordship. This is the 483 bail application on the
Which
last.
one? Which one?
Eight, madam.
Eight, item 8.
Okay,
lordship.
okay.
So on the last occasion, CD was called for lordship.
CD.
Lordship here, can you come to page number 39, that is FIR lordship, against which the petitioner is seeking the bail. The relevant portion starts from page number 39. Lordship, may I read the FIR?
Yes.
With due respect, with most humbly beg to state that as under I, Srimati Rupa Rajkot Das, wife of Dadul, as resident as Kochgaon, Ward number 2, PS, Biswanath Moza, so and so, as I'm filing this complaint against the below noted accused persons who have illegally grabbed my deceased husband's land and subjected him to mental torture, ultimately drove him to commit suicide on 27/2/25. The below scheduled land in question was lawfully property of my deceased husband Dadulas, and he had right, title, and interest over it, and it was possessing the enjoying title land is true and lawful owner. That on 23/2/25, my husband came to know some person illegally entered, trespassed, and grabbed my husband's land on 25/2/25, reached the plot of land along with his brother Partha, and found that those people were constructing kacha house. And when my husband and his brother asked those persons as to how they were constructing house on his land, then they accused person threatened my husband and his brother with dao, lathis, etc. and chased there away, saying that তোৰ ভাতিজা জোনমণি আমাক বহিব দিছে, গতিকে তই একো কৰিব নোৱাৰ, যি কৰ কৰিবি, and বেছিকে আহিলে মাৰি পেলাম. That it is mentioned here that my nephew Junmani Das is a belligerent land broker for which there are several cases pending against him, and also deals with illegal business of money lending, and the main conspirator of forcibly grabbed my husband's land, took illegal possession of, delivered the possession of the land illegally to Vishal Ghosh, Anita Paul, and Ruby Goala. On 26 to 25, Junmani met my husband and threatened and physically assaulted him in the middle of the road. In this respect, my husband had informed the concerned police and district commissioner, but they did not respond to my husband's plea that the continuous harassment and threats from the accused person caused by my husband extreme mental agony and directly leading him to suicide on 27 to 25. After my husband's death, I discovered that my nephew Germany was the key instigator behind this act. Germany manipulated and pressured my husband, instigating him to take his own life. In this illegal acts of Germany, Vishal Gose, Anita Paul, and Ruby Goala also helped and instigated him. But the delay in lodging this complaint was due to the emotional trauma I suffered after my.
All right.
But Lordship, here's the thing. The earlier also a FIR has been lodged against the petitioner. While the your Lordship has granted interim bail, and the petitioner went to the before I to appear before him, but the IO has been avoiding to appear the petitioner, but finally when the petitioner appeared before the IO, the petitioner was not aware of the lodging of this FIR, Lordship. After coming to know that the petitioner got the interim protection in that earlier FIR, the informant lodged this FIR, and then when the petitioner went to the IO, at the time the petitioner got arrested from police station itself. Only Lordship, my
How
parents.
many days you are behind bars?
40 days, Lordship, and my son is also not well, Lordship. There's no one to look after my son also.
Fact is that, Malad, yes, one person commits suicide, and as per the PM report, death is due to asphyxia as a result of antemortem hanging. Approximate time of death is 12 to 24 hours. That is there, Malad, and FIR also suicide. Now, regarding instigation to suicide, Malad, yes, there are Malad lands, total land as per the statement of the accused is around 16 bigha 4 kotha. And he stated that there are some altercations regarding the total altercation. Accused also not denied, Malad. Some altercation with the land, and because of that, Malad, he thought that these are his land. If some land of the Malad that disease, Malad, prior to that, Malad, inserted in his land, he will pay for that, Malad. That was that altercation of the earlier death. Subsequently, he committed suicide. And Malad, his land is less than that, Malad, and subsequent to that land, Malad, out of 16 bigha 4 kotha, he is some portion of it he has sold out to others, Malad. And Malad, because of that altercation, otherwise only these statements and all these are there. Malad may see the statement of the complainants, all the family members, they are saying same thing, and accused statement. I have flag mark.
It is already well. Our learned counsel Miss M. Nerula for the petitioner Jurmani Das, who has filed this. Okay, I'll grant it. Yes. Who has filed this application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars since 27/3/2025 in connection with Biswanath Saili PS case number 66 of 2025, corresponding to DR case number 171 of 2025 under section 61 within bracket 2 stroke 108 stroke 329 within bracket 3 stroke 318 within bracket 4 stroke 351 within bracket 3 of the BN single S 2023. The allegation against the petitioner is that the victim Dadul Das committed suicide on being instigated by the petitioner. Full stop. Land belonging to Dadul Das was purchased by some encroachers, and when the encroachers tried to settle on the land, Dadul Das raised objection when he learned that the petitioner allowed the encroachers to occupy his land. Full stop. When confronted, the petitioner assaulted Dadul Das and threatened him with dire consequences. The learned additional PP, learned additional PP Assam, Mr. KK and KK Parashar, who has raised serious objections stating that they are incriminating materials in the case diary against the petitioner. I have also scrutinized the case diary. It is true that there are incriminating materials in the case diary against the petitioner. However, I have considered the length of detention and the submission that the petitioner is willing to cooperate to the remaining part of the investigation. Full stop. The investigation has also progressed substantially. Full stop. It appears that custodial detention may not be required to further the investigation. Considering all aspects, petition is allowed. The petitioner is allowed on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the whom? Alaga magistrate?
Lordship, yes. Biswanath Saili.
Serious? To the satisfaction of the Alaga magistrate stroke jurisdictional court under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall not exercise threats to the witnesses, and number 3, the petitioner shall not leave the jurisdiction of the court without prior permission. Full stop. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner. Send back the CD. Can be granted, I think, instigation, I don't know.
That Elaka Magistrate will do, but it is CJM Biswanath.
CJM Biswanath. Not required to type Alaga magistrate or jurisdictional court. You type CJM Biswanath. You'll place your argument both the sides?
Lordship.
Huh?
Yes, Lordship.
লাগিব নেকি ইমান ঠাণ্ডা? দিও ন দগা ফুলে মাতি দিম লম্বা হ'ব চাগে। Yes.
My please. This is regular first appeal, Lordship. Regular first appeal.
It was about
Appeal
to be
against
dismissed
original
today.
judgment and decree.
It was about to be dismissed today.
Maybe allowed to.
All right.
Under section 96 of the CPC, Lordship. Lordship, original suit was filed by the respondent as plaintiff, Lordship, before the learned trial court, that is Court of Civil Judge number 1,
Plaintiff is
Kamrup
the
Metro.
respondent now, no?
Lordship. Title suit number 436/2011 was filed, Lordship. and suit was decreed without considering some vital materials available in the case record, Your Honor. That is why I have preferred this appeal, Your Honor, basically on the ground of perversity, arbitrariness, material irregularity, and violation of certain laws. Before coming to Your Honor, my memo of appeal and judgment, kindly peruse plan first, Lordship. Lordship will find at page 17, annexure 1.
Okay.
Suit filed by two sisters, that is present respondent, Lordship, Cherry Count and Barbie Count, against Heritage Home Reality, that is developer, Lordship, who was represented by Pradeep Gogoi, Managing Director of the builders. Their basic allegation against the respondent, Lordship.
Just a moment. I think I won't be able to take up, I think. This person is my relative, I think. Pradeep Gogoi. I won't be able to take up, I think. I know he is a developer and builder, but I don't know his exact name. But I know his
Handicapped
nickname.
person, Lordship.
Hmm?
One leg is handicapped.
Handicapped?
Cannot yet.
Oh, he is handicapped.
Handicapped.
Are you sure?
Yes, sir.
Okay, then he is not my type.
Handicapped.
Not the person I'm thinking of.
He could not even walk properly
Pradeep
without
Gogoi.
assistance. Yes, Lordship.
Okay, then carry on, carry on. Carry on. What is his address?
Lordship, here address is mentioned. If your Lordship kindly peruse memo of appeal, page
17.
page 2. Pradeep Gogoi, Beltola. Let me see the affidavit. Beltola, Lordship. At present, he is about 70, 69, 70.
Yes, he's around 69, 70.
What's up? And they allow me if photo is there in a WhatsApp. Okay.
He's around 69, 70. Yes, no doubt about it.
If you Lordship don't mind.
Yes. Because I don't know his formal name, I know his nickname. No, no, no. Yes, you can carry on.
Annexure 1, Lordship, page number 17. Suit filed by two sisters. They claims to be the landowner of 1 bigha, which is subject matter of the suit, as and also same is described in schedule of the plan. And against that, Heritage Home Reality and its managing director, that is defendant number 1 and 2. Kindly peruse, Lordship, paragraph 3, that is page number 19. Paragraph 3 of plan.
Yes.
Here the plaintiff claim regarding ownership of 1 bigha of land, clearly. The plaintiffs are the absolute owner of a plot of land measuring 1 bigha, which falls Dag number 79, covered by Patta number 3, situated at Revenue Village, Daranda. Yes, regarding ownership. Then kindly peruse next. Paragraph 4 is vital, Lordship. The plaintiffs and defendant have executed an agreement on 12/6/2008 at Guwahati. Prior to the agreement amongst them executed on 24/2/2009 in respect of same subject matter and in respect to the same plot of land shown in the schedule below with the defendant. However, due to certain inconvenience regarding the mode of the payment, both the parties and defendants had cancelled the agreement dated 12/6/2008 by mutual consent and entered into a fresh agreement dated 24/2/2009. Hence, at present, said agreement dated 24/2/2009 stands. So basically, their basis is, Lordship, this particular agreement this particular agreement was exhibited by both sides. I am also exhibited the same as exhibit 2 and exhibit B, and the plaintiff side also exhibited the same lordship as exhibit 1, admitted document. Then kindly peruse next paragraph, lordship. The defendants, being a builder promoter, was desirous for constructing three residential buildings upon the scheduled land, and the plaintiffs, being the absolute owner and possessor of the said land shown in schedule below, allowed the defendant to construct a residential building on aforesaid scheduled land, and both the plaintiff and defendants agreed to terms and conditions laid down in agreement dated 24/2/2009. Then, lordship, basically here admission on the part of the plaintiff, your honor, both the parties agreed to comply the terms and conditions as laid down in agreement dated 24/2/2009. Then, your honor, next paragraph. Under the terms and conditions, the agreement dated 24/2/2009, the defendant were supposed to pay the plaintiff an amount of rupees 72 lakhs in following manners. So, as per terms and conditions of that agreement, lordship, that has been explained, your honor, in A regarding 6 lakhs on April 2009, then B 12 lakhs to the plaintiff in equal to installment in July 2009, October 2009, January 2010, and then April 2010, and remaining amount of rupees 14 lakhs, lordship, will supposed to be payable by the defendant to the plaintiff on the month of July 2010. So, then D, the defendant were supposed to pay aforesaid installment as per post-dated check to the plaintiffs. As per agreement dated 24/2/2009, and more particularly deed number 2451/2009, it is laid down that if the defendant fail to pay or default in payment of aforesaid amount within the specific time mentioned herein, then the defendant were put to liable for payment and interest at the rate of rupees 18% per annum upon the defaulted amount to the plaintiff.
Yes.
It is laid down in the agreement dated so and so.
Yeah, agreement will be like that only, yes.
Yes. Then, your honor, they made a serious allegation against the defendant, your honor, in paragraph 7 and 8. As per terms concerned on completion, as per the terms concerned on completion of the then proposed construction. This part, lordship, vital. As per agreement concerned on completion of the then proposed construction, the defendant shall transfer the right of the existing building to the intended purchaser, and the defendant shall have the right to sell part or parts of the scheduled land to the prospective purchaser to realize the sale process thereof, for which, as per agreement concerned, the plaintiff were supposed to execute power of attorney in favor of the defendants to the execute and to do the acts, things, deeds as the true attorney on behalf of the plaintiffs in respect of the construction upon the said scheduled land. Then, paragraph 8. The defendants gave the plaintiff the necessary checks as per stipulation of the agreement concerned, but out of those 4 account pay checks were not honored. When those had been deposited before their bankers, out of said 4 checks, payee checks, 2 of the checks were in the name of plaintiff number 1, and the other 2 checks were in the name of plaintiff number 2.
Okay.
Yes, these checks
4
were
checks
given.
dishonored, okay.
Now, my humble and respectful submission, your honor, this case basically based on that development agreement. As per own statement of the plaintiff side, your honor, they made submission with affidavit before the learned trial court first, your honor, claiming ownership of 1 bighah of land. Then, your honor, it is also admission on the part of the defendant that as per agreement of that agreement, the plaintiff was supposed to, the defendant, the builders were supposed to pay 72 lakhs on a condition that they will hand over 1 bighah of land And over there on the builder will construct total 3 buildings. And as a whole, the the builder's liability to pay 72 lakhs. And the plaintiff primary duty is to, Your Honor, hand over that 1 bigha of land, and then to assist the builders to construct 3 residential flats. This is the summary on the part of the plaintiff side, Your Honor, regarding their ownership as well as terms and condition of the agreement 24 to 2009. And
Construct
that
3 residential flats.
3 residential flats over 1 bigha of land. Here, the sake, my humble and respectful submission, Lordship, those sakes or payment are not independent. Those are contractual on the basis of that that development agreement. Those sakes are not at all independent, Lordship. And defendant's liability, the builder's liability will come only then, Lordship, if the plaintiff able to hand over 1 bigha of land and defendant construct 3 residences.
Yes, I got your point.
Now, kindly peruse, Your Honor, before coming to my written statement, kindly peruse that agreement. Lordship will find Annexure 2, page number 28. This was exhibited by plaintiff side, Your Honor, as Exhibit 1. I have also exhibited the same as Exhibit B. Here, page number 29, 3rd paragraph. Your swearing is there, internal page 2, Lordship. The first party is the absolute owner of a plot of land measuring 1 bigha, covered by dog number 79, patta number so and so, so and so. That part of land. Here, the summary is there in last paragraph also in the same page, Lordship. And whereas the second party is desires of constructing 3 residential buildings upon the aforesaid land. Then, Your Honor, kindly, before coming to other part, kindly peruse page number 32. That description of that land. Schedule, 1 bigha of land within 4 specific boundary. Same is also described in the plan, Lordship. Then kindly peruse page number 30, clause number 1. Page 30, clause 1.
Page 30.
30. That agreement, Lordship.
Page 30, clause 1, yes.
Here, specific clause is there, Lordship. Just the first party shall deliver and vacant possession of the land to the second party to construct the said residential building.
Okay, yes.
Then kindly peruse clause number 4. The second party, in lieu of construction and sale of the residential building, shall pay an amount of rupees 72 lakhs. Yes, that part is there. Now kindly peruse my written statement. What was the defense of the builder's side?
Okay.
Annexure 3, page number 33. I will show only relevant
Okay,
part
I
of it.
understand.
Since I have already prepared a written argument, I will submit immediately completion of my oral argument. Paragraph 3, Lordship. The plaintiff have instituted the present suit by suppressing material facts. The plaintiff have suppressed from this honorable court regarding the fact that as per revenue record, only 10.72 R, that equivalent to 4 kotha, Lordship, stands in the name of plaintiff. Out of it, they have already sold out 1 katha 9 leases of land in favor of another person. Plaintiff have also suppressed from the honorable court that out of 3 buildings permission mentioned in the agreement, 1 permission was subsequently cancelled by the concerned authority, and out of remaining 2 permission, 1 permission was obtained in the name of Hiranya Count, who is not party to the suit. In view of the present suit instituted by the plaintiff is liable to be dismissed with cost. My major allegation, Your Honor, the plaintiff was not owner of 1 bigha of land, whereas as per revenue record, as per possession, the plaintiff was owner of 4 kotha of land. And that is why, Lordship, out of 3 buildings, the defendant developer constructed only 2 buildings. And out of that 4 kotha land, 1 katha 9 leases was sold to one Abdul Hannan, And that the defendant side not only proved that sale deed by bringing the same into the before the learner trial court in original as Exhibit C, but the purchaser of that land also adduced evidence as DW2 lordship. I will show from the record itself.
Okay. Purchaser of that 1 kotha land.
Yes, less, 1 katha less. And 2 building was constructed due to less of that land, not 3 lordship.
2 buildings constructed, not 3.
Not 3 lordship.
Okay.
For better appreciation, if your lordship allow me to read basic facts as stated in written statement, lordship, page 36.
Yes.
Page 36, lordship, paragraph 21A.
Page 36.
Page 36, lordship, paragraph 21A. A and A, B, and C, the entire brief facts stated by the defendant side. That will help your lordship also. Married lordship, that the plaintiff number 1 and 2 as owner and possessor of a land measuring 1 bigha covered by Dag number so and so, village so and so, had obtained building permission for construction of 3 multi-story residential apartment in their name and the name of their father here on account. However, plaintiff have failed to start any construction work and they have approached the defendant number 1 company with a request to take over the construction work over said land. Accordingly, an agreement was entered between the plaintiff and defendant company in this regard. As per agreed terms and conditions of the agreement, the defendant company had agreed to pay 72 lakhs in total to the plaintiff against the construction and sale of flats, 3 apartments on ownership basis to buyer. Next paragraph, lordship. Though the agreement total area of land is mentioned 1 bigha of land, but at present the revenue record the total area where land shown as 10.72 r. Moreover, they were found in physical possession of an area measuring 4 kotha. It ought to have been, Your Honor, 4 kotha. That was wrongly, Your Honor, type. I will show from the record itself. For which construction of 3 apartment house obtained permission by the plaintiff earlier were not physically viable. Therefore, the plaintiff, their father, and defendant number 1 being director of the defendant number 1 company held a discussion to sort out the problem. In the said meeting, it was amicably decided between the parties that out of 3 apartments agreed to construct over land of the plaintiff as per agreement dated 24/2/2009. 2 apartments will be constructed by the defendants covering 3 katha of land and 1 katha 9 lesas of land will be sold out to any intended buyer oblique purchaser. It was also agreed between the parties that in view of construction of 2 apartments instead of 3 apartments, as agreed, their defendant company have to pay 2/3 amount from the earlier agreed amount of rupees 72 lakhs, that is 48 lakhs, lordship. Moreover, the defendant's company have to pay the sale amount of the remaining 1 katha 9 of lesa of land to the defendant after execution of sale deed. In terms of subsequent agreement verbally took place between the parties, the defendant company have constructed 2 apartments and of the ownership flat over 3 katha of land and sold out all the flats to the various individuals along with the proportionate share of the land. Moreover, remaining 1 katha of land of vacant land is sold to one Abdul Hannan by registered sale deed for an amount of rupees 2,90,000. Therefore, the plaintiff company is required to pay rupees 48 lakhs, being 2/3 amount of rupees 72 lakhs towards value of 3 katha of land and 2 apartments constructed over it. The defendant's company also paid another amount of rupees 3 lakhs towards the value of the land sold to Abdul Hannan. That 3 permission obtained in respect of the said plot of land of the plaintiff, 2 permission were obtained in the name of plaintiff number 1 and 2, and third one in the name of the father their father Hiranya. Therefore, the Hiranya had also executed a power of attorney in favor of the defendant's company. Hiranya has also entered into an agreement 21 to 2009 with the defendant's company. Moreover, subsequently being building permission obtained in the name of plaintiff number 2, Barbie count was cancelled by the concerned authority. That at the time of entering development agreement with the plaintiff, the total amount payable to the plaintiff regarding 1 bigha of land and where 3 apartments were to be constructed was fixed 72 lakhs. And therefore, as agreed between the parties, defendant company through defendant number 2 had issued post-dated check amounting to rupees 72 lakhs to the plaintiff. That was at the time of executing agreement. However, after subsequent development had cancellation of construction of one building, it was agreed that the plaintiff will not use those checks issued by the plaintiff after getting their subsequent agreed amount and shall return unused check to the defendant's company. But the plaintiff never returned those unused checks, and the defendant's company, who have very good terms with the plaintiff on good faith, never demanded return of those unused checks. However, those checks were not in any right. Those checks does not any of the. This is the basic facts, Your Honor. Lordship, kindly now peruse on the basis of those the dispute between the parties, what issues were framed by the learned trial court. Lordship will find the issues framed by the learned trial court. Annexure 6, page number 58. As many as page 58. 7 issues were framed.
Yes. This is a judgment, no?
Judgment of Lada trial court, Lordship. Yes. Issue number 1, a non-joinder of further, Lordship, not so vital. Suit hit by provision of estoppel waiver acquaintances. Next, Your Honor, issue number 3, 4, and 5 are vital. Whether the plaintiff, issue number 3, whether the plaintiff has suppressed material facts in the plan, and if so, whether the suit is maintainable in its present form. Regarding suppression, that specific issues are framed. Then, Lordship, issue number 4, whether the agreement dated 24/2/2009 is binding upon the defendants. As because, Lordship, those checks are outcome of this agreement. That is why these vital issues are framed. Issue number 5, whether the defendant is liable to pay 21 lakhs to the plaintiff in terms of agreement and rupees 3 lakhs towards compensation with interest of at the rate of rupees 18%. Next, Your Honor, entitled as paid for any other relief. Here, my entire argument will confine basically on issue number 3, 4, and 5.
You've already argued. You've already argued.
Lordship. Now, what then kindly peruse the outcome. What learned trial court was considered.
Yes.
Just I want to summarize one thing, Lordship.
Yes,
if your Lordship kindly
Outcome
is.
is required.
Yes.
You can project the outcome.
What basically the plaintiff said adduced evidence of both plaintiff as PW1 and PW2. The plaintiff side, Lordship, exhibit, if your Lordship is this point is vital, Lordship, that agreement as exhibit 1,
Yes.
power of attorney as exhibit 2, sex which were dishonored, Lordship, that was exhibited as exhibit 3, and communications, all communications as exhibit 4 to exhibit 8. And the defendant also adduced evidence of 2 witnesses, that is managing director as DW1 and this purchaser of 1 kata 9 lasses of land as DW2. And the defendant side exhibited, Lordship, exhibit A, the patta of the land. Lordship knows very well. Patta is regarded as title deed. That patta which stand in the name of Lordship plaintiffs were exhibited without any objection as exhibit A. Patta.
Exhibit A, no?
A.
Okay.
Exhibit B, same agreement, Lordship.
Yes, yes, yes.
Exhibit C is vital, Lordship. That's sell deed, whereby the land of the plaintiff measuring 1 katha 9 lesas was sold out to Abdul Hannan. That is exhibited and bring into original Lordship, bring original copy of the sell deed as Exhibit C and same power of attorney as Exhibit D. Now kindly peruse, Lordship. The defendant side categorically stated regarding suppression of material facts, basically ownership, area of the land. But what happened, Lordship, if you are kindly peruse the discussion and decision of learned trial court at page number 59, issue number 3.
Yes, page number 59, yes.
Yes. So that issue, Lordship, was whether the plaintiff have suppressed material facts in the plan. If so, whether the suit of the plaintiff is maintainable in its present form. Here, I may be allowed to read only 10 to 15 line, Lordship.
Okay.
Entire issue. To prove the case, the plaintiff number 1 and 2 has filed evidence on affidavit and exhibited the agreement dated 24/2/2009 as Exhibit 1. Power of attorney Exhibit 2. For dishonor's sake as Exhibit 3. Notice issued to the plaintiffs to the defendants dated so and so as Exhibit 4, 5, 6, 7 and reply of the defendant as Exhibit 8. Therefore, both the plaintiff were cross-examined mainly on the point that for dishonor of sex, NIX cases were filed and same are withdrawn. But it has came out that defendant has requested father of the plaintiff to withdraw the case and accordingly same were withdrawn after payment of rupees 5 lakhs to the plaintiff number 2. To plaintiff number 2. Thereafter, the present case has been filed. But from the evidence on record and analysis of the pleading of the case, it is not clear what materials facts have been suppressed by the plaintiff for which the suit is not maintainable in its present form. Therefore, I am of the opinion on that the instant suit is maintainable. Hence, the issue is decided in affirmative.
Yeah.
Repeatedly in my written statement, it was specifically pleaded that the plaintiff have suppressed their ownership. Their owner only land measuring 10.72 are not 1 bigger land, Lordship. That specific statement were there. And if your Lordship kindly once again peruse the reply of the defendant side against statement made in paragraph 3. In paragraph 3 of the plaintiff, Lordship, the plaintiff side specifically claim about their ownership over 1 bigger of land. Against that statement, Your Honor, Lordship, the defendant side categorically denied. Lordship will find in paragraph 9, page number 34. Paragraph 9, page number 34, the defendant categorically denied ownership of 1 bigha of land. Lordship knows very well, when some facts asserted by the plaintiff side and same is denied by the defendant side, then issue raised. And if the defendant side specifically denied their ownership, Lordship, over 1 bigha of land, so definitely as per evidence act, burden lies on the plaintiff side to prove that they are the absolute owner of 1 bigha of land, not 10.72 lesser as claimed by defendant.
Yeah.
But very unfortunate, Lordship, the learned trial court, in spite of having that patta regarding ownership of 10.72, I also from the record, Lordship, and other statement and evidence, single word is not been, Your Honor, reflected in while decide issue number 3. Single line is not there, Lordship. In fact, it is held that.
No, see, now you have taken the land. You have taken the land.
I got possession, Lordship.
Then you are building a flat.
I got possession only 10.72 lesses.
Yes, yes.
After getting possession, a meeting was held between the parties.
You
And-
constructed a flat,
Yeah, I constructed only two flats lot, two apartment lordship.
2 apartments, but you didn't hand over the apartments to the plaintiffs.
No, that land was lot, the meaning of the agreement was the landowner need 72 lakhs against 1 bigha of land. They need not require any ownership flat lordship. As per terms of the
Okay.
agreement.
All right, all right. It's okay.
Is-
But you are supposed to construct 3 flats.
3 flats. But as the land was not 1 bigha lordship, that is why lordship, the builder, developer,
It's okay, it's not 1 bigha, it's 3 katha, maybe 4 katha.
yes lordship.
But is it only 48 lakhs in dispute?
That is between the parties lordship. They did not claim till that. They did not sought any decree of declaration of fraud lordship. That's agreement for sale is liable to be cancelled. That prayer is not there, Your Honor.
Okay.
So here only pleading is the both party agreed that here the specific statement on the part of plaintiff side lordship as per terms of the
So now you are not willing to return how much? 21 lakhs.
I have already paid against 2 apartment lordship. I have already paid 48 lakhs. That is admitted.
And now you are not willing to pay how much?
I am also the landowner also received sale consideration amount which was sold to Abdul Hanan.
No, it's okay. But you are not willing to pay how much? Abdul Hanan is okay. They
21
have sold,
lakhs.
I agree. They have
21
sold.
lakhs lordship.
You're not willing to pay 21 lakhs.
21 lakh.
It's
As
okay then.
because lordship that
I understand why you are not willing to pay. I understand.
yes lordship.
So we'll hear the other side.
Lordship, kindly allow me to next.
How much
further
you
submission.
want to say?
It will take only 10 minutes, Lordship. My humble and respectful submission, Your Lordship. The plaintiff was supposed to hand over 1 bigha land.
No, I
As per
understood. My
agreement,
God, I understood.
Yes.
I tell you.
failed to hand over. So, Your Lordship, the liability of the defendant to pay payment of for 24 into 2 against 2 apartments. That is 48 lakhs. And sale consideration of remaining land, that is 3 lakhs was paid to the landowner lordship after executing Exhibit C sell date. Exhibit C sell date.
So which sums up to 48 lakhs or more. 48 plus 3.
48 lakhs plus 3 lakhs.
Technically 51 lakhs.
Plaintiff was supposed, builder was supposed to pay another 24 lakhs for after construction of 3rd apartment. Since the defendant failed to construct 3rd apartment and the plaintiff decided to sell out that land to one Abdul Hanan, that is why that Abdul Hanan paid 3 lakhs to the landowner through the defendant. So 24 minus 3 lakhs, that is 21 lakh, that has exactly claimed by the plaintiff side. My humble and respectful submission, Lordship, those checks which were issued at the time of executing the agreement, Lordship, in the year 2009,
Yes, 2009.
that agreement was executed in the year 2009.
Yes.
And Your Honor, that sale deed, that is Exhibit C, was executed on 12/8/2010 after more than 1.5 years. After more than 1.5 years. And kindly parents, Lordship.
Just a moment, this agreement was executed in the year 2009.
Yes, and sale was made, Your Honor, by Exhibit C on 12/8/2010.
Sale did after 1 year, no?
After 1.5 years. About 1.5 years. Now kindly peruse the patta.
On 20?
On 12/8/2010. About after 1.5 years.
Okay.
Then kindly peruse, Your Honor, patta at page 40 of my memo appeal. Page 40, Lordship will find patta. Page 40 and 41 translated copy. Effective part, Lordship, at page 41 against dag number 645, second basti 10.72R. Page number 41, column 3.
Dag number 641, okay.
Yes. Here, Lordship will find the name of the plaintiffs, that is present respondent, as pattadar number 6 and 7 at page 40, Barbie count and Seri count.
Yes.
Since some other lands are there, that is why some other pattadars also there.
Yes.
Now kindly peruse original copy at page number 42. And column number 4 at page number 43. Dag number 645, DTO Bosti 10.72R. And this is Patta Lordship. So Patta is regarded as title deed. And interestingly, Lordship, although the plaintiff side claim they are owner of 1 bigha of land, single documents has not been disclosed, not been filed before the learned trial court to prove their title. Their primary requirement was, Your Honor, to prove ownership over 1 bigha of land. If 1 bigha of land is there, then the liability of defendant side will come, Lordship. So since the plaintiff suppressed their actual ownership, and rather the defendant side placed this patta and without any objection, then kindly peruse, Lordship, the sale deed. Lordship will find page number 44. That's sale deed.
Okay.
Annexure 5. This was exhibited as Exhibit C. Barbic-Hound executed through attorney, that is respondent side. In next page, page number 45, Lordship will find name of the purchaser, Abdul Hannan. And interestingly, Lordship will find another part at page number 52. Barbic-Hound as witness number 1. Page number 52.
Okay.
Barbic-Hound, that Barbic-Hound.
This is exhibit C, no?
Exhibit C. Exhibit C. Now, after deciding issue number 3, Lordship, without considering that suppression, which I have categorically stated in my written statement and also submitted Exhibit B Patta, the learned trial court did not consider anything. And then next issue, Lordship, issue number 4, whether the agreement is binding upon the defendants. Here, the statement is there in the plan itself, Lordship, not only defendant, both the sides are binding. Both the side exhibited same agreement, Lordship. From plaintiff side as Exhibit 1 and the defendant side as Exhibit B.
Okay.
And as per that agreement for itself, the plaintiff side is bound to hand over possession as per clause 1 itself, Lordship. And then clause number 4. As per clause 1, the plaintiff is duty bound to hand over 1 bigha of land. And as per clause 4, if he plaintiff side able to hand over, then my liability will come. If your Lordship kindly peruse the discussion and decision of issue number 4,
yes,
that suppression of material facts regarding ownership of 10.72 not 1 bigha, those were not at all considered. Lordship will not find any discussion on Exhibit A Patta in entire judgment, Lordship. Exhibit Patta was not considered at all. And that
Exhibit A is a patta, no?
Patta. That was not considered in deciding any of the issues framed by the learned trial court.
Okay.
And same in case of decision and discussion of issue number 5, 6, and 7. The learned trial court decided the sued, Lordship, as if since the defendant side issued the check and checks were dishonored, therefore the defendant are liable to pay the amount. Whereas my submission, Lordship, my respectful submission, those checks were not independent. Those checks are based or outcome of that agreement, development agreement.
Well, understood. I understood.
And in this regard, Lordship, I have, Lordship knows very well, plaintiff must approach the court with clean hand. So suppression of material facts is amount to fraud, playing fraud before this honorable court. So stating all these facts, Your Honor, and I have also relied various judgment of Honorable Supreme Court. Written synopsis, Lordship. I'll also have copy to opposite side, Lordship. Since the issue number, Lordship, 3 to 5 is very much necessary, Lordship will find my entire submission from page 2. Issue number 3, issue number 4, and issue number 5.
Okay.
With all applicable law and judgment in support of my case.
Okay.
Lordship, as per pleadings described in order 6 of the CPC, Lordship. So as per order 6, Lordship, rule 4, plaintiff is duty bound to disclose all material facts. As per order 6, rule 4. And Lordship, consequence on failure or negligence of order 6, rule 4 always attract order 7, rule 11 also.
Okay.
Some judgment I have placed, Lordship, non-disclosure of willful non-disclosure of Lordship cause of action or any facts can lead order 7, rule 11, Lordship.
Yes.
Some judgment are there. And Lordship knows very well. By executing that Exhibit 1 and Exhibit B agreement for sale, the plaintiff landlord played fraud, which attract Section 17 and Section 19 of the Indian Contract Act, Your Honor. And in this regard, Lordship, the Honorable Supreme Court 2010-14 SCC page 38, 1994 page 1 SCC page 1, 2024 Supreme Court, and 2007 4 SCC page 21, and 2008 12 SCC page 481, all judgment I have placed, Lordship.
Okay.
Explanation is there in my written argument, Lordship.
All right.
And Lordship, my humble and respectful submission, Your Honor, it is admitted position since the defendant plaintiff side did not object on patta, Lordship. It is established that plaintiff was owner 10.72, not 1 bigha.
Yes, yes, of course.
My only Your Honor, since the plaintiff defendant side was agreed to follow all the terms and conditions only on presumption that the plaintiff will hand over 1 bigha of land. Since the plaintiff has failed to fulfill their primary duty regarding handing over of flat, Lordship, so that's why that there is the liability against those checks which were issued at the time of executing agreement for sale
Okay, I understand.
will
about
not
the
binding,
checks.
Lordship. Then, Your Honor, issue number 4 against regarding bindingness of that agreement for sale. Already I have facts submitted my facts, Lordship. In this regard, I have placed some judgment 1997 Supreme Court, Lordship, and 2012 Supreme Court. If the first party landowner is failed to comply his part of land, then defendant side or second party is not binding to comply the terms and conditions. In this regard, these 2 judgments are there, Lordship, will find against submission of issue number 4, as stated in my written submission. Your Honor. And regarding issue number 5, Lordship will find from page 10 of my written synopsis, liability of that amount. Here, some judgment of Honorable Supreme Court is there, 1969 Supreme Court, 1962 Supreme Court, and 1993 Supreme Court. Only it was held by the Honorable Supreme Court since those 6 were not independent. Those 6 are outcome of that agreement for sale. So, dishonor of those 6 will not create any liability upon the defendant side. Your
Okay.
it is based on contractual terms and conditions agreed by the parties, Lordship. So here other judgments I have relied, Your Honor, in support of my case. Lordship will definitely go through at the time of passing. Lordship.
Otherwise,
So let the opposite party. They are part of
I have to go through.
Yeah. So in view of
Each and every point I will have to go through.
yes, Lordship. In view of ignorance to consider material facts that itself, Your Honor, established the judgment passed by learned trial court is perverse, arbitrary, and material irregularity, Your Honor. So issues were
Oh. Yes, yes.
that and another I want to add only one point, Lordship. While cross-examining the PW1 and 2, that both PW1 and 2, Your Honor, admitted that they failed to submit any document to prove their ownership over one behalf. Both PW1 and PW2, Lordship, plaintiff side. That is admitted. Plaintiff 1 also admitted, plaintiff 2 also admitted, Lordship. Here, clear admission on the part of PW2. I have not filed any document in this suit in support of the claim that I, along with my sister, is the owner of one bigha of land. We have already sold one katha of land, but did not get money. So, at best, Your Honor, the plaintiff side claim which the defendant failed. So, plaintiff side cannot claim, Your Honor, 24 lakhs after deduction of 3 lakhs sale consideration amount, 21 lakhs, Lordship. Because the check issued against 20 lakhs were based on handing over possession of one bigha of land and construction of 3 apartments.
Now, that apartments have been sold off to clients?
Yes, Lordship.
Okay.
And plaintiff, defendant side categorically established that the plaintiff is owner of 10.72, not
Yes,
one.
yes, I'll not
Since
forget,
the
never.
plaintiff failed to establish their title over one bigha of land, so defendant is not binding, Lordship. So therefore, the judgment passed by the learned trial court apparently, Your Honor, bet and same is liable to interference by this honorable court.
Okay.
May I summarize? The case has been projected by the appellant is totally incorrect because the submission or statements made in the appeal should be supported by evidence. If evidence is otherwise, these statements have no leg to stand. In this particular case, Lordship is aware, it is the land in Guwahati, in the village, that is, Lordship will find in the plain itself, that is the land that is the land at Dwardhanda Gaon, Beltola, in the district of Kamrup Assam. And he is the builder, he wants to construct the building. Now the present suit, Lordship will find the present suit what has been paid. This is not a suit for performance of contract. This is a suit for realization to the amount which is paid by the plaintiff defendant. Lordship will find at page 18. Page 18. This is not a suit for specific performance contract.
Yes, yes.
This is a suit for injunction and recovery of rupees 24 lakhs with compensation along with the interest hereon. And there is no counter claim here on, Your Lordship. The counter claim by the respondent that less land has been given, so I am not entitled to pay 21 lakhs, which is supposed to be paid as per post-dated check given to the plaintiff.
Okay.
Now you can see where plaintiff are resident, page 17. How they have treated the plaintiff, Your Lordship. Plaintiff are resident of Your Honor. One is Pune, one is Delhi. They have been cheated by the builder in land below Guwahati. 1 bigger land, they have paid 48 lakhs, and not 48 lakhs, total 51 lakhs has been paid. According to them, 48 lakhs is supposed to be paid because they have constructed 2 buildings. In lieu of that, they have to pay 48 lakhs. Admittedly, they have paid total 51 lakhs to the plaintiff. And balance amount this check has been bounced, that is why present case has been filed. Your Lordship can find total amount due, page 21, para 8. Amount paid check number demand, check of SERI count is 7 lakhs. Second check is 6 lakhs in favor of SERI count. Page 21. Chart has been given.
Yes, I saw the chart.
7 lakhs, then 6 lakhs to the SERI count. Next, Lordship will find 7 lakhs, 6 lakhs to the Barbie count, and 7 lakhs to the Barbie count. This is check 1, 2, 3, 4. Chart has been given. This check has been dishonored, and thereafter notice has been issued, and they have given the reply that has been executed by the plaintiff. What has been replied? Now case has been manufactured that less land has been given. That is why he is not liable to pay the amount. They have manufactured the WS against the statement made in the reply to the given in the notice, demanding payment of the said amount. And that document has been executed by the plaintiff as documents number 5, 6, 7, and 8. Now, Your Honor, Your Lordship, in this particular case, Your Lordship will go to the evidence on record of Pradeep Gogoi. What is his defense? His statement has been recorded and he was cross-examined. Lordship can see the LCR.
Can see. Can you sound? We'll see. The evidence of fact. Evidence of fact to it, I later take. Cross examination.
I think C file will be required.
C file will be required.
The C file is there, Lordship.
Yeah, is here.
I will take your Lordship directly to the cross-examination part of Pradeep Gogoi, the appellant hearing. It was recorded by the commissioner. Lordship.
হেৰি petition submission হ'ল draft issue খিনি আছে on a draft issue নাই PW1 cross examination, no?
Lordship, the Pradeep Gogoi, PW1. Before Commissioner I.L. Chaudhary.
Oh yes, I'm getting.
Lordship, got it?
Handwritten.
Handwritten. PW1.
DW1, no?
Pradeep Gogoi.
Yes.
Lordship, got it? So, Lordship, defendant number 1 is a company. I am the director of the company. I have made the agreement with the plaintiff to construct a building on the plaintiff land. Lordship, got it? Plaintiff has executed power of attorney in my favor in respect of the said land. Said agreement was made on 24th day of February 2009. As per agreement, the area of the land was 1 biga covered by Dak number 79 of KP Pata number 3 of Village Dondara under Beltola Moja. I have seen the land at the time of executing the agreement. He has Hereafter also he has said that before executing the agreement, there was an earlier agreement with the appellant. And before executing the agreement, he verified the land. What is the actual position of the land? I have seen the land at the time of executing the agreement. Very important, Your Lordship. The land was in the name of Cherry Khan and Burby Khan. Without verification of the land, he has not executed the agreement. Power of attorney of the said land was given to me by Cherry Khan and Burby Khan and Hiranya Khan. Said power of attorney was registered. As per clause 4 of the agreement dated 24/2/09, in lieu of construction and sale of the residential building, second party shall pay ₹70 lakhs to the third party, to the first party. Exhibit 3 is the check dated 34/2010 of Bank of Baroda was issued by me for ₹6 lakhs in favor of the Cherry Khan. Signature appearing in the photocopy of the exhibit 3 series, my signature. There is no dispute that the check was issued by him and check signature here. Check that the demand of Bank of Baroda of 7 lakhs issued in favor of Cherry Khan Bindra was issued by me. Check that the demand of Bank of Baroda of 6 lakhs in favor of Burby Khan Bora was issued by me. Check that the demand in Bank of Baroda of 7 lakhs issued by me in favor of Burby Khan. So there is no dispute regarding the amount of check issued by him. All the checks were exhibit 3 series were not dishonored. According to him, these are not dishonored. According to us, these are dishonored, and thereafter, plaintiff has been compelled to file the present suit for realization of the amount. Total amount, as per this amount, Lordship will find that total amount will be around 26 lakhs. Lordship will find 4 check. Total amount will be.
Yes, I have counted it. It's 26 lakhs.
26 lakhs. Out of
14, 7, 7, 14, 6, 6, 12, 26 lakhs.
26 lakhs. After case has been filed under Negotiable Instrument Act, he has approached the father of the plaintiff and paid ₹5 lakhs. That is why present case has been filed for realization of ₹21 lakhs. Till that time, he has not objected that less land has been given. That is why I am not ready to pay rupees this amount of state which has been issued. After filing suit under the NI Act, he paid ₹5 lakhs to the plaintiff. And after getting 5 lakhs, case under the NI Act has been withdrawn. Thereafter, he again stopped making payments. Thereafter, present suit has been filed for realization of ₹21 lakh. All the 6 exhibits is not dishonored. It is a fact that all the 6 exhibits were dishonored by my banker. Plaintiff has not issued me any notice regarding dishonor of the check. I cannot recall now whether I have received the registered notices issued by the plaintiff to me. I have not denied about non-receipt of registered notice issued by the plaintiff in my evidence on affidavit as well as in WS. In the plaint, we have stated that after dishonor of the check, we have issued notice to him that this check has been dishonored, make payment. And regarding issuing of notice demanding payment, he has not denied in the WS. I will take your lordship to directly to the plain where we have stated that after check has been dishonored, we have issued notice. Lordship will kindly see page 22.
Yes.
Of the plain. Plaintiff who were waiting for the necessary amount of money would be deposited in the account of by the defendant as assured by the defendant verbally many times, but as expected, good sense did not prevail upon the defendant, and the limitation has also run out for filing a case under section 138 of NI Act. Situation compelled the plaintiff to issue notice 13/6/2011, 9/7/2011 to the defendant for violation of the terms of condition of agreement for the reasons stated above, and also inform the defendant for determining the agreement and dated 24/2/09 and power of attorney to executed by the plaintiff on 24/2/09. Defendant replied to the said notice dated on 25/7/2011 and acknowledged the receipt of the notice so sent by the plaintiff dated demand and 9/7/2011. In reply to the notice, defendant stated that defendant in pursuant to the agreement 24/9/2000 has already made payment through various checks. As such, defendant are surprised to receive notice from the plaintiff and express the grief of the defendant by hearing the word silence. Defendant in reply has not expressed their clear intention for clearing the dues of the plaintiff. Furthermore, finding no alternative, plaintiff served 2 individual notices to the defendant for paying up the outstanding dues, and thereby informed that if defendant did not clear the dues within the stipulated period, as mentioned, he would settle not only for his failure to pay the amount to the time of rupees 24 lakhs, along with interest as per annum, but there would be imposition of compensation for losses and negligence on the part of the defendant. Notice has been issued for revision of the check, and he has said he has paid some amount in cash and to the plaintiff. That is why he is not liable to pay the amount. Lordship will kindly see para 30, page 35, para to the para reply to the para 10, what they have stated. What we have stated, I have written already in para 10. What is the reply? Reply para 14. Okay.
Okay.
Defendants has denied correctness of the statement within paragraph number. As regard to statements within paragraph number 10, it is stated that answering defendant have already complied with their part of agreement, and therefore plaintiff are not entitled for any amount from the defendant in respect of the agreement is falsely claimed by them.
Which paragraph?
Paragraph 15, page 35.
Yes, yes. I was reading 14.
What we have stated in paragraph 10, that for not realizing the amount, we have issued notice. He have not denied. He had only stated that he has already paid the amount.
Okay.
Now, Your Honor, Your Honor, I have given reply to Sherry Khan and Barbie Khan, Bora again in the evidence again, which are exhibited by plaintiff as exhibit 6-7 against the notice dated 13/6/2011 and 9/7/2011 of the plaintiff. Lordship will find the exhibit 6 and 7 is the reply. Nowhere stated that these amounts are not liable because of the amount.
6 is figure 6 or Roman 6.
No, exhibit 6 is 6.
Figure 6.
Figure 6.
Exhibit 6 and 7. These are the replies.
Reply. Nowhere stated that because of the receiving less land, he is not liable to pay the amount. These are afterthought. Said replies contains my signature. He has admitted that exhibits 6 and 7 contain his signature. Though I have mentioned in WS that I have constructed 3 buildings as per agreement, but I have constructed 2 buildings instead of 3. But said facts are not mentioned by me in exhibit 6 and 7. That because of getting less land, he had constructed 2 buildings. That is why he is not liable to pay 26 lakhs. That has not been mentioned in exhibit 6 and 7. Reply demanding payment. I have sold 1 kotha 9 lakhs of land out of 1 bigha as attorney of the plaintiff to the Abdul Hannan. It is also admitted that he has sold the land 1 kotha 9 lakhs on the basis of power attorney. It is sitting on the part of the plaintiff has been seated. He has sold out of 1 bigha 1 kotha 9 lakhs has been sold to Abdul Hannan. That is admitted by him that he has sold. You will find again page 6 of the prosecution part. I have sold 1 kotha 9 lakhs of land out of 1 bigha as an attorney of the plaintiff to Abdul Hannan. He has sold. I have not sold. He has sold the land to 1 kotha 9 lakhs. Page 6 of the prosecution.
Okay.
I have sold 1 kotha 9 lakhs of land out of 1 bigha as an attorney of the plaintiff to the Abdul Hannan. He has sold 1 kotha 9 lakhs of land to Abdul Hannan on the basis of the power attorney given by the plaintiff, Your Lordship. Now he said he gets less land. That is why he is not liable. And Exhibit C is the sale deed dated 12/8/2010, executed in favor of Abdul Hannan by me. Total land was in the name of Cherry Khan and Barbie Khan as per Exhibit 1 as well as Patta. Exhibit C sale deed 12/8/2010, Barbie Khan was known as owner of and seller of the land. Exhibit C was executed by me on the basis of power attorney, being deed number 724 of 09 dated 24/2/09, which is marked as Exhibit 2. I have sold the said land for an amount of rupees 2,09,000. I can contradict that this amount 2,90,000 has been inserted in the sale deed on the basis of the value of the land, government value, and actual price is more than that. And that has been admitted by Abdul Hannan, who has purchased the land. Abdul Hannan, he was cross-examined. He has admitted that actual price of the land is more than that 2,90,000. But by check, he has paid 2,90,000. That is why 2,90,000 has been inserted.
Because of government value.
Government value. There was nothing in Exhibit C that 2,90,000 was received was paid into the Barbie Khan. He has said that Barbie amount received by him 2,90,000 has been paid to me by after receiving
Abdul Hannan.
from Abdul Hannan. He has paid the amount to me. There is nothing because Abdul Hannan said that said amount has been paid by check in favor of Pradeep Gogoi. And there is nothing on record that this 2,90,000 was also paid to the plaintiff. It is not a fact that I have executed Exhibit C on the basis of the power attorney without taking consent in favor of the in favor of the plaintiff. Without consent, he has sold the land. That is why suggestion has been given. I am a builder. For the purpose of buying and selling a land is measured, and thereafter documents are verified and possession is verified. Very important, Your Honor. Your Lordship. He has admitted that as a builder, I am a builder. He has admitted, Your Lordship, I am a builder. For the purpose of buying and selling, a land is measured, and thereafter documents are verified, and possession is verified.
Yes, yes.
He has verified before execution of the agreement. In the first paragraph also said that before making agreement, I have verified the land and possession. Thereafter, he executed the agreement.
Yes, yes.
It is a fact that at the time of execution of Exhibit 1, I have measured the land. Again admitted, I have measured the land, but I have verified the documents and possession of the land before executing Exhibit 1. He has verified the land, document, thereafter he has executed Exhibit 1. That is the agreement for construction of the building. Now he is saying that less land has been given. And out of that, he has sold out 1 kotha 9 lakhs of land to Abdul Hannan at a consideration of rupees 2,90,000. Before Exhibit 1, there was an earlier agreement executed between plaintiff and me. Before this agreement,
That is in the plaint also.
yes, for construction of the
This
land.
was again revised.
I have taken out the three separate, I have taken the suit land separate, three separate building permission in the name of the respective land mentioned in the schedule Exhibit 1. I have consulted the architect for the design of the building. Thereafter, architect has verified the land and prepared the design. As per the said design, I have constructed the building. I have not given any written notice to the plaintiff regarding finding of leased land. Now they have stated that he getting leased land. Till date of filing of the evidence and affidavit, till date of cross-examination, he has not issued any notice to the plaintiff that actual land is less than 1 bigha. He has not issued any notice. This is a written agreement, Your Lordship. And without issuing notice that he's received less land, how harbily he can say that I have received less land, so I will pay less amount? Everything is written. Again, I am reading, Lordship. I have not given any written notice to the plaintiff regarding finding of less land than 1 bigha before filing the suit. Very important, Lordship. It is not a fact that to avoid liability, I have taken this stand that there is less land than 1 bigha. It is not a fact that I have seated the plaintiff taking advantage of innocent lady and being resident of outside of Assam. Both are resident of Your Lordship, Pune and Delhi. They have been seated by the builder. In Guwahati, 48 lakhs of rupees for 1 bigha of land. Can you believe? Before signing the agreement dated 24/2/09, there was an earlier agreement between me and the plaintiff. That agreement was also for construction of the building in respect of the same plot of land. State building permission was obtained by me in their names. Fresh agreement was made on 24/2/09, which is exhibited by Exhibit 1 in the suit showing Xerox document. Said agreement was registered on 24/2/09 before the sub-register Guwahati. The said agreement was signed by me and Cherry Khan and Burby Khan. I have signed on behalf of Heritage Home Realty Developers Private Limited as a managing director. This is registered private company. I have seen the photostat copy of the certified agreement in the court record, which bears my signature in every page, as well as in the last page, including the signature of the Cherry Khan and Burby Khan in last page, under objection. Exhibit 3 dated 34, under objection will have no value, Lordship. There is no dispute regarding the agreement. Bearing my signature issued in favor of Exhibit 3 dated 34/2010 is a photocopy of the check for ₹6 lakhs bearing signature issued in favor of Cherry Khan Bindra. This is under objection by the defendant. Exhibit 3 series dated 37/2010 is the photocopy of the check issued in favor of Cherry Khan Bindra for ₹7 lakhs of Bank of Baroda. It is under objection. What will relevant get objection? He has admitted that he has issued a check. Now he said under objection. Exhibit 3 series dated Iman issued in favor of Burby Khan Bora of Bank of Baroda for ₹6 lakhs bearing signature under objection. Exhibit 3 series dated Iman issued in favor of Burby Khan 7 lakhs bearing my signature under objection. Aforesaid 4 checks were issued or not dishonored by the bank. According to him, these are not dishonored. In my reply, I have not mentioned about realization of my any amount. I have paid payment of some amount in cash also to the plaintiff. In my WS, I have not written how much money I have paid in cash to the plaintiff. He has said some amount has been paid in cash. What is the cash amount? Even if the receipt is produced that I have paid the amount in cash, no receipt has been produced. It is a fact that I have not made any payment in cash to the plaintiff, and that is why I have not stated in my WS. In WS, he has not stated that he has paid some amount in cash. One, what is the amount? I came to give evidence on last date. I had an account in Bank of Baroda, which was cash credit account, being number Iman. Exhibit 3, which is the original thrown to me today in court for ₹7 lakhs issued in favor of Cherry Khan Bindra, dated Iman. In my check, signature is not mine. Now his signature denied. Now check has been produced to him. He said, these are not my signature. But he has admitted that check has been issued. Now he said, because of less land, I am not entitled for the amount. Now, Your Lordship, the document which has been exhibited by him as Exhibit A, that is the patta of the land, which has been exhibited by him, showing that Exhibit A contained less land. Your Honor can see, Your Lordship can see page 18 of the cross-examination part.
Yes, page 18.
Page 18. Exhibit A bears the seal of the Office of the Seventh Officer, Guwahati, on the top of it, which is Xerox 1. That is a Xerox 1, Lordship. Exhibit A, patta has been shown, that is Xerox 1. Signature and seal of the issuing authority are photostat. Original 2 seal appearing in the page number 1 and 2, and Exhibit A does not contain any signature of any official of the concerned authority. The Exhibit A, the patta which has been exhibited by him, do not bear any seal and signature of the official.
Okay.
It is not a fact that the original seal appearing in Exhibit A are manufactured seal by me. I cannot say before Exhibit A how much land belongs to which patadar. Exhibit A contain various land. We do not know how much land belong to Serikhan and Barbican. Your Lordship can see the Exhibit A. Exhibit A is a patta photocopy of a patta.
Yes, sir.
But he do not disclose how much land Serikhan Barbican has. He said less land. I cannot say from the Exhibit A how much land belongs to which patadar. I do not remember the present on which tag number and patta number I have constructed the building. He also do not know where he has constructed the building. Rothin Das was the architect who designed the said building. He resides in Bamuni Medan. His official assistant have helped me in obtaining necessary building permission. I have not submitted the copy of the building permission and drawing copy of the said building in the court. He has not exhibited the building permission as well as NOC before the court in evidence and affidavit. That only two building has been constructed and 2 building permission has been given, 1 has been cancelled, no document has been produced. I have obtained building permission for constructing 3 buildings in the suit land of the plaintiff from GMDA. Now admitted that he has obtained for 3 buildings from GMDA. GMDA, that means GMDA has allowed him to construct 3 buildings. Because he has sold out 1 kotha 9 acres of land, he could not construct. GMDA has made a joint inspection in my presence and presence of my architect before issuing me the building permission. Lordship, in this particular case, it is admitted position that GMDA, after inspection of the land, in his presence as well as in presence of architect,
Yes, yes,
inspected the land, and after that, allowed to construct 3 buildings.
yes.
It is very important, Lordship, because he said that I could not construct 3 buildings because of less land, but GMDA, in presence of him as well as architect, allowed him to construct 3 buildings. After spot verification and going through the documents, GMDA has issued the building permission. It is not a fact that I have stated in para 4 of my evidence on affidavit that moreover plaintiff were found in physical possession of an area of 4 kotha 9 acres of land to avoid the liability.
Only. Yes, yes.
To avoid the liability as per agreement. What I have stated that to avoid the liability, you have said that I have received 4 kotha 9 acres of land. Your Lordship knows 5 kotha is equal to 1 bigha. According to him, he received 4 kotha 9 acres. He less 11 acres of land, according to him. He could not know, he do not know how much land Barbican and Serikhan has as per Exhibit A. That is a patta he has produced as Exhibit A. He do not know how much land Exhibit A contains. And Exhibit A is a photocopy. He has not called the revenue official to prove Exhibit A that less land is there. It is not a fact that I avoid the liability. I have not submitted the copy of the building permission obtained from GMDA. In this count, it is disclosed the correct position. I have already constructed 3 more residential buildings in the Guwahati as a builder. I have not exhibited the sale deed exhibited by me in favor of purchaser of the apartment in 2 residential buildings constructed over the suit land belongs to the plaintiff. I have given proportionate share of the individual buyer where I have constructed the building. Said sale deed also contain dark number and patta number as well as the area of the land. It is not a fact. To conceal the real fact, I have submitted copies of those sale deed. I have not submitted a copy of the sale deed in this case. I have completed the construction of the building 3-4 years of time after the agreement. I have not sent any notice to the plaintiff informing less land was found than the actual land. Very important, Lordship. I have not sent any notice. This is a clear admission on his part. I have not sent any notice to the plaintiff informing that less land was found than the actual land. It is very important, Lordship.
Yes, yes.
I have not stated in my reply dated 25/7/2011, which has been marked as Exhibit 6, about getting less land than the actual land. Earlier notice has been issued regarding not receiving the money. In the notice reply also, they have not stated that because of the receiving less.
That you have mentioned.
Lordship. My signature does not changing daily. It is not a fact that Exhibit 6(1) is my signature on being shown to the plaintiff Exhibit 6. In my earlier cross-examination, I have admitted that Exhibit 6 was issued by me. Earlier, he has said that exhibit 6 is issued by him. Now he said exhibit 6 signature is not mine. It is not a fact that I am speaking lie before the court on the instruction of my advocate. Exhibit B is a certified copy of the agreement dated 21/2/2009. Exhibit B, the number of the bidding permission in written in page number 2. I have issued advance check which were post-dated to the plaintiff amounting to rupees 72 lakhs for construction of 3 buildings. Exhibit E is the certified copy dated 29/3/09, agreement dated 24/2/09, executed between the plaintiff and myself. Exhibit E is under objection being their certified copy dated 29/3/09. Exhibit P is marked as by the plaintiff. Both the agreement has been exhibited by him and myself, and original also exhibited by exhibit 11. Original sale deed has been called from the office of the sub-registrar, that has been marked as exhibit 11. Now he is denied the agreement also. Agreement dated 24/09 was executed in the office of the sub-registrar, Guwahati, Kamrup. I and the plaintiff had put their signature as a party to the agreement. I do not recognize the signature of both the parties appear in exhibit E. Agreement dated 24/09 contains as clause for giving 18% interest on default of the amount. As per agreement, Lordship, 18% interest is supposed to be paid, but Honorable Court has declared only 6%. But as per agreement, he is liable to pay 18% interest if they got dishonored. I have sold 1 Katha 9 lessons of land on behalf of the plaintiff on behalf of the plaintiff to Abdul Hannan. I have adduced evidence of Abdul Hannan in the suit as DW1. I have not exhibited sale deed executed in favor of Abdul Hannan in my evidence. Said sale deed contains my signature. Said sale deed is in the possession of the Abdul Hannan. I pay income tax. Now, Your Honor, Your Lordship, the Abdul Hannan evidence is very important. That is recorded on 21/11/19.
Okay.
21/11/19.
Yes, yes.
Your Lordship knows for swearing an affidavit, plaintiff deponent have to appear before the advocate commissioner or before the notary public for signature. What he has stated, I have signed my evidence on affidavit in my office situated at GNB Road, Panbazar, Guwahati. I do not know who else apart from me had put his signature in the evidence and affidavit. He do not know that it was notarized. In the before the notary public, everyone signed. It was signed before me by the deponent. But he do not know it bears signature of the notary public because he signed in the office at GNB Road, Guwahati. Defendant have taken my evidence on affidavit in my office. I have signed it. He signed in his office.
Yes.
Evidence on affidavit has been prepared by the defendant number 1 and I have put my signature. What has been stated in evidence on affidavit is not his statement. It was prepared by defendant number 1, the builder, Pradeep Gogoi, and he put his signature. What is the value of his evidence? Then also I will realize some statement. I know defendant number 2 from 2009. I purchased the land. I know the owner of the land. I have not met her in court when I came for registration of the land. Your Lordship, I have met her in court when I came for the registration of the land. I have not seen the revenue records of the land before registration, but I do not remember now whose name appeared as a owner. In Exhibit C, the name of the seller is shown as Barbie Khan, Bora. Defendant number 2 has been shown me the power of attorney on the basis of which sale deed has been executed by defendant number 2. That is.
Actually, this is translated Ditya Pakha, they asked no. So that he or she translated to defendant number 2.
Defendant number 2 is. It should be defendant number 1. Defendant number 2 is the.
No, because they said Ditya Pakha, no, that is why.
Defendant number 2.
Ditya Pakha.
No, now defendant number 2 is the.
I understand.
I do not have the copy of the same. Exhibit B is the power of attorney. And today I have seen it in the court. Exhibit D were given by Barbie Khan, Terry Khan, and Hiranya Khan. It is a fact that in my sale deed, Exhibit C, name of Seri Khan and Hiranya Khan was not mentioned. It is very important, Your Lordship,
Yes.
because land belongs to jointly Barbie
Yes,
Khan,
yes.
Seri Khan. But in the sale deed, only name of Barbie Khan has been mentioned. And power of attorney is of 2%, Barbie Khan and Seri Khan, as well as Hiranya Khan.
Yes.
But in the sale deed, only Barbie Khan name has been inserted. So he sold the land of Barbie Khan. Which portion Barbie Khan? That is not partition. I have made the father of the Barbie Khan at Pan Bazar, but I do not know his official. I have not made Barbie Khan and Seri Khan before registration of my sale deed. He has not made Barbie Khan or Seri Khan before execution of sale deed. I have not discussed regarding price. I have not discussed price of the land which I have purchased by the Exhibit C. Price of the land has been not discussed with Barbie Khan or Seri Khan. I have purchased 1 katha 9 lakhs of land and price was fixed by the defendant number 2. I have paid the sale price to him. I have not made any payment of money personally to Barbie Khan and Seri Khan. He has said that money has been paid to Barbie Khan and Seri Khan, but he has admitted that I have not made any payment of money personally to Barbie Khan and Seri Khan. He has not paid. Before registration of the sale deed, I have paid the sale price to defendant number 2. Officially, the sale price was 2,90,000. Now, you know, very important.
Yes.
Official sale price was 2,90,000. But actual price was how much I paid, I do not remember. But actual price was more than 2,90,000. It is more than 50 lakhs or 40 lakhs. But he has, in document, he has written 2,90,000. I am possessing the land which I mentioned in Exhibit C, and I am doing myself the construction work here. I went with the defendant number 2, while defendant number 2 went to the make payment to the father of the Barbie Khan. I do not know how much money did defendant number 2 pay to him. It is not a fact that my sale deed is not a valid one, as because land belongs to Barbie Khan and Seri Khan, and the sale deed name of only Barbie Khan is appeared. I do not know about official process of mutation, but land is mutated in my name. It is not a fact that my mutation was done fraudulently. I have seen 2 buildings, one is suit land, but I do not know how total area of the land and boundary of the suit land. Exhibit C, I did not annex identity card of Barbie Khan, though identity card of all the witnesses and seller and purchaser are annexed. So, Lordship, in the sale deed, generally, the Aadhaar card is annexed in every sale deed. But here in the sale deed, Barbie Khan document is not there. It is not a fact that the signature of Barbie Khan are manipulated, and she was not present at the time of registration, and that is why her identity was not annexed. Because, Lordship, Barbie Khan was not present, his identity card was not annexed with the sale deed. That is my suggestion, and that has been established.
When was the land sold? Which year?
2010.
That the Aadhaar card was not annexed. 2010.
But in this particular case, your Lordship can see Aadhaar card, PAN card is there. Every document of the seller and purchaser is there. In the sale document Exhibit C, every seller and purchaser document are there.
Maybe it was there. Maybe I forgot exactly, but it was.
Land was sold
Ah.
at a more than the price shown in the sale deed. Very important.
Yes.
Land was sold at a more than the price shown in the sale deed.
Yes.
That is admitted.
Everybody practices this.
But he has admitted that sale price is 2,19,000 is only the official document. It is more than that. Present value of my land is more than 50 lakhs. He has admitted that present value of the land is more than 50 lakhs in 2010. And he has sold the land at 2010 at rupees 2,90,000.
The cross-examination in there 2019 lot.
19.
Okay, 19. I do not remember if I had purchased the land at a value of more than 42 lakhs. I have paid 2,90,000 by check and rest amount in cash. He paid 2,90,000 in check and rest amount in cash. I do not remember what amount has been paid in cash, and same is not in my record. I do not know if defendant number had seated the Birmingham and had not paid any amount, any money to him. I have not seen the identity card of Birmingham. Later on, she said he has seen the identity card of the Birmingham. I do not know whether the lady present in the court was Birmingham. He do not know Birmingham was present in the court. I have shown Birmingham, who is the Birmingham. He could not identify. Later on, witness said, I made an inquiry from the identity card that she is the Birmingham. After verifying the identity card, she said she is the Birmingham. I do not know, remember which identity card of Birmingham I have seen. It is not a fact that the Birmingham was not present that day. In my evidence on affidavit in para 2 and 9, I have stated that the owner of the land are Cherry County and Birmingham, both the plaintiff. I do not know at present how much land in the name of both the plaintiff. It is not a fact that I have deposed falsely in this case in order to save defendant number 2. So in this particular case, Your Honor, Your Lordship, case is fully established by the plaintiff from the evidence of the cross-examination part of the defendant number 2 itself, that there is no notice that less than has been received, and in lieu of that, he have to pay less amount. Nothing on record. That is a defense taken in the WS, first time, to establish that he is liable to pay only 48. So, and the Lordship will find in the judgment itself, trial court has discussed everything. Page 59.
I've read it, page 59.
Page
60.
59, issue number 3. To prove the case, plaintiff 1 has filed evidence on affidavit and exhibited agreement that a
It
demand.
was read.
And now he has
The
said,
entire paragraph was read.
it is clear from the materials have been supposed by the plaintiff, which the suit is not maintainable in the present form. Therefore, I'm opinion that suit is maintainable. Hence, issue a decision affirmative. And after that, your Lordship will find issue number 5 and 6. Page 62. It is also admitted that second party is liable to pay rupees 70 lakhs. He also admitted that Exhibit 3 series Bank of Baroda check has been issued from Bank of Baroda, but he denied that check were not dishonored. It is also admitted by W1 that he received registered notice regarding dishonor of the check. He also admitted that he has given reply to the said notices and said reply contained his signature. It is also admitted that he sold 1 kata 9 acres of land to Abdul Hannan on the basis of power attorney dated 24/2/09. Said land has been sold at rupees 2,90,000. There was no mention that the said amount was paid to the Birmingham and plaintiff number 2. It is also admitted that before execution of the agreement, he verified the land documents, position and measurement. It is also admitted that he has not issued any notice that he has received less land than as per agreement. As a result, he could not construct 3 multi-story buildings. During cross-examination, it is stated by W1 that no statement regarding payment of some amount to the plaintiff in cash was made in written statement. In written statement, he has not stated that some amount has been paid in cash. During cross-examination, W1 denied signature of the check Exhibit 3 series, but same were not denied in the written statement that he has no knowledge whether his check were dishonored. He also admitted that he has not exhibited the building permission as well as drawing. Regarding receipt of less land, it is admitted that he has not issued any notice to the plaintiff, though he has not taken a defense that
That I have noted down. You will submit the authority? You'll have to conclude, but its time is going to be over soon. Not required. You repeat the same thing. Already you have repeated so many times. Hmm. Please don't repeat. Please don't repeat. Hmm. This is repetition. You don't come on facts. No, I'll produce. I'll produce. I'll produce. I'll go into it. Get into it. Why you are replying on facts? You want to read it. You want to read it. Cross-examination. So you cannot repeat, but see, you kept on repeating that. Less learn so many times. Okay. Okay. Yes, yes. I'm getting only PW2. Cross-examination of PW2 only. I'm not getting cross-examination of PW1. PW2 or PW1? Yes. PW2, 3, 4, but PW1 I'm not getting. 2, 3, 4, DW1, 2, every cross-examination I'm getting except PW1. Not getting. Citation PW1 or cross-examination. Okay, but no problem. Let it buy weeks on. Yes, give me the certificate copy, yes, if you have one. Do you have a copy? Then you'll have to read. It's okay, I'll go through it because you don't have to submit on fax. Mm. Mm. Okay. PW3. PW3? DW3 I have. I have. Mm. Mm.
How much very interesting.
Yes, I saw it. Yes, I saw it. Why? It is not an NIA case. I have noted it down. I have noted it down. Please conclude. Please conclude. I won't be able to absorb anymore now. These are facts again, not for the second time. Again for the on the facts, no. If you want to place on law points, yes. Yes. It is admitted, no? Yes, you have a point. Okay. Okay. $10.7 acres, no? Are I understood that time you have repeated so many times. I know the checks were post-dated checks issued at the time of exhibitor. There were 4 buildings to be constructed, 3 buildings, only 2 were constructed, so you don't want to pay the money. That is it. I will go through everything in detail, but unfortunately I cannot find the cross-examination of PW1. Now, let's see if I'll get it while dictating the judgment. Now I cannot find. Okay. Yes, I have seen. Yes. Mm. Okay. Yes, yes, I've been. She's a woman. There also I've noticed. Okay. Yes. Third learned council, Mr. I think this carry went on for 2-3 hours, I think. Huh? First, definitely. Very serious matter. R. Ali for the appellant and learned counsel, Mr. S.K. Goswami for the respondents. Reserve for judgment and order. Edu judgment and order. Technique headache notes. Yes. Written argument, okay. Learned, it will learned counsel for the, offer, offer also. Learned counsel for the appellant has also submitted written argument and copy has